Hello everyone, and thanks for joining Keating Chambers live webinar. I'm Holly Gavahan, Business Development Director at Keating, and I'd like to introduce today's speakers, Adrian Williamson QC, Sean Wilkin QC, and Matthew Finn. Over the next half an hour, Matthew will outline the general principles relating to force majeure provisions and explore various issues that may arise when a contracting party seeks to rely upon the COVID-19 pandemic as a force majeure event. We'll follow this with Adrian and Sean responding for half an hour to a selection of topical issues that have been raised as questions in advance. There's also a Q&A panel on the right of your screen if you'd like to type in a question during the webinar. If a question is published and you'd like it answered, please click on the thumbs up icon. I'll hand you over to Matthew.
Thanks, Holly. Thank you everybody for joining. Welcome. I hope everyone's keeping safe and well in these slightly strange times. As Holly said, this session is going to cover some pretty topical ground, looking at the interrelationship between force majeure and COVID-19. Now, prior to December 2019, I doubt many of us found ourselves regularly dusting off force majeure provisions to subject them to detailed analysis. But I suspect that will change markedly in the months to come, if it hasn't already. There's quite a lot of ground to cover, so I'll jump straight in. It's perhaps dangerous to say this at the start of an online webinar, but I have set out a bit more detail on the slides than I would ordinarily, so you can always revisit any particular slides if you're keen to avoid childcare responsibilities later. So, first and foremost, what is a force majeure clause? Well, as we all know, the term force majeure is of French origin and is recognised by civil law systems. So if you were to look at this French civil code, you'd see force majeure recognised there. But the common law in this jurisdiction, by contrast, recognises not force majeure, but frustration, which is a relatively narrow doctrine. And so in this jurisdiction, force majeure is a creature of contract, and it's entirely down to the parties to choose whether to include a force majeure provision in their contract, and if so, the breadth of that clause. Now, in circumstances where the term force majeure is not a term of art in English law, what's the best definition to adopt when analysing the subject? I think the best definition is that set out in Chitty, which describes a force majeure clause in this way: a contractual term by which one or both of the parties is entitled to cancel the contract or is excused from performance of the contract in whole or in part, or is entitled to suspend performance or to claim an extension of time for performance upon the happening of a specified event or events beyond his control. And the only point that I'd add there is that that definition doesn't expressly refer to the requirement, which is invariably imposed by contract, that there be a causal link between the specified event on the one hand and the impact upon performance on the other. And we'll deal with that causal requirement in a bit of detail later on. Now, to the extent relevant, how does one categorise a force majeure clause? I think it's important to note that historically there has been some degree of confusion or lack of clarity as to whether or not a force majeure provision amounts to an exemption clause. But ultimately, if one looks at the recent case of Classic Maritime, it appears that the courts are in line with a general drift in the interpretation of commercial agreements, inclined to focus upon the content of the term and not to put unduly restrictive labels upon it. So assume that we have a client who considers that performance of his contract has been adversely affected by the COVID-19 pandemic and wants to know whether it can rely upon force majeure to excuse non-performance. What does that client have to prove? Well, generally speaking, and subject always to the terms of the contract, there are 5 main requirements in play. The first is that a specified event that falls within the contract clause has occurred. The second is that the relevant effect upon performance has occurred. The third is that it was due to circumstances beyond that party's control. The fourth is that there were no reasonable steps that that party could have taken to avoid or to mitigate the event or its consequences. And fifthly, and again depending on the terms of the contract, that all notices have been given. And if all those 5 requirements are satisfied, one then generally looks to the contract for guidance as to the relief or the remedy which flows from that. Now, what I intend to do in this talk is to focus predominantly upon requirements 1 and 2 from that slide, which I consider are likely to be the areas where there's greatest scope for disputes in the coming months and years. So looking at the first of those requirements, the occurrence of the specified event, let's just place ourselves historically. What has historically been held to constitute force majeure? We see things there like storms, tempests, floods and fires. And what by contrast has been held to be outside the purview of force majeure clauses, bad weather and football matches, unsurprisingly. And I feel as though when the football season returns in what will surely be the cultural event of the decade, I'm afraid I still can't see the TCC distinguishing priestmen. In certain cases, the force majeure clause might expressly refer to pandemic, epidemic, disease, or even plague, albeit, as I've set out on the slide, those terms are not commonly in use in standard form construction and engineering contracts. But that obviously may well change as drafting committees get to grips with the COVID pandemic in due course. In my view, where that sort of wording is used, that very likely will respond to COVID-19 generally. So if, for example, the direct cause of non-performance on site is a dearth of workers who are ill as a result of the pandemic, then it seems to me that that would probably satisfy the occurrence provision. But the important caveat to that, which we'll come on to when I address causation in section 2 shortly, is that I think it will be imperative to be clear in future disputes whether, legally speaking, it's COVID-19 or some other event which ought properly to be regarded as having impacted upon performance. So wherever I use an asterisk in future slides, that reflects the fact that the conclusion I express there is subject to that important caveat on causation. Now, in certain contracts, the term pandemic or epidemic won't be used, but the term act of God may be used, and that's been described by the House of Lords as a metaphorical phrase like fate with a religious origin, used to describe those events which involved no human agency and against which it was not realistically possible for a human to guard, an accident which the defendant can show is due to natural causes, directly and exclusively, without human intervention, and which could not have been prevented by any amount of foresight, pains and care reasonably to be expected of him. Now, again, it seems to me that generally that sort of wording would respond to or be engaged by COVID-19. And perhaps the only two further caveats to that conclusion are that if ultimately COVID-19 proves either to be a man-made disease or possibly that it can be shown that it escaped from a lab in China through to negligence, and I say that both of those eventualities seem to be rather unlikely at the moment, then it may well be that the analysis of an act of God provision changes because it would be arguable that human intervention could be established. Turning now to a few of the standard form contracts in use in the construction and engineering industries. If one looks at the JCT standard building contract, that provides in two places for force majeure at clause 22.29.15 and 8.11.1.1. The first of those clauses provides that force majeure is a relevant event, and the second provides that force majeure is a matter which may permit termination of the contract. Now, as I've set out on the slide, the term force majeure is not expressly defined in the JCT standard building contract, but I think that notwithstanding, COVID-19 generally probably would fall within those clauses. And I say that because if you look at authorities of the type that I've set out on the slide, there are suggestions there that a pandemic of this character probably would fall within the definition of force majeure, even when the term is not further delineated. Looking next at the FIDIC Red Book, the two major editions that I'm going to focus on are the 1999 edition and the 2017 edition. You'll see from the slide that clause 19.1 of the 1999 edition defined force majeure as an exceptional event or circumstance which satisfied the four requirements set out in limbs A to D. And then it went on to offer a non-exhaustive list of events which might constitute force majeure, which included natural catastrophes such as earthquake, hurricane, typhoon or volcanic activity. In the 2017 edition, the term force majeure has been replaced with the term exceptional event, see clause 18.1, but both the definition and the list of events set out in the contract are largely the same as the 1999 edition. Now, again, it seems to me if one looks at COVID-19 generally, so subject to the caveat on causation that I've already mentioned, my view is that there's a respectable argument that COVID-19 ought to be regarded as an exceptional event broadly akin to the natural catastrophes listed in the contract. And it seems to me that their similar reasoning probably applies to that which applies when interpreting an act of God provision. Now, whether the limbs A to D are ultimately satisfied will be a question of fact in each case, but I think that limb B is particularly interesting because it seems to me that insofar as disputes are concerned with contracts entered into prior to, say, December 2019, it would appear unlikely that a court would hold that the party alleging force majeure could reasonably have provided against it. But insofar as contracts have been entered into after that date, it seems to me that matters become much more fact sensitive, and it may be that parties entering into contracts as of today's date would find the court taking a very different view. And on that front, if one looks at Chitty 15155, that states that it's arguable that a party ought not to be able to rely upon a force majeure clause, which, and I quote, as the result of facts known to him at the time of entering into the contract, he could reasonably foresee would inevitably come into operation and so affect the performance expected of him by the other party. And it seems to me those contracts being concluded now or in the months to come may well see disputes in which that argument is tested before the courts. Moving on then to NEC 3, clause 19.1 provides for prevention, and it states that if an event occurs which neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it would have been unreasonable for him to have allowed for it, the project manager gives an instruction to the contractor stating how he's to deal with the event. And again, as with JCT and FIDIC, it seems to me probable that the COVID-19 pandemic generally would fall within that clause. And if one follows the contract through, clause 60.119 states that such an event is generally a compensation event. But it seems to me that there are important further considerations that have to be borne in mind when looking at NEC 3. The first is that an event of the type that I've just described is only a compensation event under clause 60.119, where it is not one of the other compensation events stated in this contract. And it seems to me that in that connection, the COVID-19 pandemic could conceivably constitute an employer's risk and therefore a compensation event under clause 60.114. And equally, if the project manager gives an instruction in response to the COVID-19 pandemic, which serves to change the works information, it may be that there's a further or alternative compensation event arising under clause 60.11. So those conclusions are specific to the terms of the NEC 3 clause, but what those further provisions remind us all of is that it's important to follow the relevant contractual provisions through and look at them in their proper contractual context, rather than becoming fixated on the force majeure provision alone. So moving on now to the second major requirement, I've already mentioned that most force majeure clauses require that there be a causal link between the specified event and the non-performance in order for relief to be obtained. And I think that causation is going to be an area that's obviously going to be fiercely fought over, not only factually, but also on matters of legal analysis as well. And before jumping into that, I think it is worth noting that there are some rare force majeure clauses which are worded in a way which does not strictly require proof of such cause and effect. So if anyone's interested in finding out a bit more about that, it might be worth looking at the analysis of the Ford and Sons case in Tritles for frustration and force majeure, para 12027. Now, generally speaking, force majeure provisions impose a causation requirement by stating that the relevant specified event must have prevented, hindered or delayed performance of the contract. Now, where the relevant term is prevented, or the contract provides that the party must be unable to perform, that obviously comprises the highest hurdle. and the case law establishes that generally where that sort of wording is used, performance must be legally or physically impossible, not just more difficult or unprofitable. That seems to me it's conceivable that the COVID-19 pandemic may make certain contracts strictly impossible to perform, but I think it's much more likely that successful reliance will be placed in due course on those force majeure clauses which merely require it to be proved that the works on site have been hindered or delayed. Hindered, then, what does that term mean? Well, it's broader than prevented, and it includes situations where performance would require dislocation of business and breaking of contracts, but again, does not generally include situations where performance has merely become more expensive due to a rise in prices. But those conclusions are all subject to the terms used in the particular contract in question. So it's not inconceivable that certain force majeure clauses might be engaged upon economic change of circumstances. And as I've set out in the slide, as is commonly the case, and we all know what's meant by the term delayed, the meaning of that depends upon the context and the other words used in the contract. Now, one of the issues that's likely to arise in respect of causation is, must the party seeking to rely upon the force majeure clause prove that the force majeure event was the sole cause of the impacted performance? Now, I think it's generally accepted both academically and judicially that ultimately that's a question of construction of the words used in the contract. But if one looks at recent cases such as Seadrill, I think it's clear that in the majority of instances, and absent special wording, the force majeure event will generally be regarded as something which only affords relief if it is the sole cause of the impacted performance. Now, we come on now to the very important caveat that I mentioned at the start of this talk. Thus far, we've assumed that when analysing a force majeure provision, the courts will be particularly interested to know whether the COVID-19 pandemic generally falls within the specified events listed in the contract. But I think it's important to bear in mind that the COVID-19 pandemic has set in train a series of other events rippling out from the centre. So by way of a non-exhaustive example, we have had in England the making of primary legislation and regulations, the production of diverse and ever-changing industry guidance and best practice. Now, looking at those sorts of events within the four corners of the site, those responsible for managing site operations will have had to take decisions on how, if at all, to adapt to the new normal. Those decisions may or may not have been based upon a correct reading of the relevant legislation, regulations and guidance. Those decisions may also have been taken without any real regard to the letter of the legislation, regulations and guidance. And equally, looking beyond the four corners of the site, the pandemic will in many cases have affected third parties upon whom those operating on site rely for the supply of materials, labour and professional services. And that's before one even comes on to consider the impact of foreign law on supply chains, labour movement and that sort of thing in projects with an international dimension. Now, in each case where the force majeure clause requires a causal link to be established, the really key question, it seems to me, is what is the putative event which has caused non-performance? Now, on one view, one might say that all of those things have been caused by the COVID-19 pandemic generally, and therefore if the pandemic generally falls within the range of specified events covered by the force majeure clause, then the clause ought to be regarded as engaged and available to give relief to the party in question. But for my part, I think that's too simplistic. Obviously, if those matters have prevented, hindered or delayed performance of the contract, and wouldn't have happened but for the COVID-19 pandemic, then the pandemic's a factual cause. But as we all know, that's not necessarily sufficient to establish causation in law. So it seems to me that it's likely to be fact specific in each case as to whether the pandemic generally or some follow-on event, such as those listed on the slides, ought to be regarded as the true cause of the non-performance. So to that extent, there is a feedback loop between requirement 1 and requirement 2. And in many cases, it may be that the ripple effect, not the pandemic itself, is the putative event held to have caused non-performance. Now, the factual permutations arising out of those matters and the various interactions between them is well beyond the scope of this talk. But what I propose to do is look just briefly at some of the most important legislation, regulations and guidance that have been made or published in England. Even there, because those documents are so diverse, what comes should be regarded as strictly non-exhaustive, but I hope it gives a flavour of the types of issues that may arise in practice in the coming months. I'm conscious that there are certain people dialed into this webinar who are not based in England, but I hope that the analysis of what follows may nevertheless be of interest, having regard to legislative changes in your jurisdiction. So looking first at primary legislation, the principal piece of primary legislation that we're concerned with is the Coronavirus Act 2020, which permits the Secretary of State to prohibit or impose restrictions upon entry into or departure from certain premises in England. Now, construction sites haven't been ordered to close pursuant to those provisions, but there obviously remains a prospect of that in due course. And I think the only other points to bear in mind in relation to primary legislation is that there are different legislative regimes in place in England, Wales, Scotland and Northern Ireland. So it's important to check carefully for differences of approach and wording. Now, moving on to regulations, those which have closed businesses and restricted movement and gatherings are the Health Protection Coronavirus Restrictions England Regulations 2020, and those have been made not under the Coronavirus Act 2020, but under the Public Health Control of Disease Act 1984. And it's perhaps those regulations and possibly guidance which has followed off the back of them, which will have had the most impact upon those operating in the construction industry, along with their suppliers. Now we move on to guidance, and I think before jumping in here, it's important to bear in mind that when one moves from legislation and regulations on the one hand to guidance on the other, one might ordinarily start from the proposition that guidance is policy and not law, although I understand that Sean, who'll be speaking shortly, is currently working on an article which addresses, amongst other things, the legal status and effect of the guidance. And I believe that should be published later this week. So if you want a bit more of a detailed guide, that's the place to go to. But the fact that the guidance is of a different character, it seems to me, is it potentially important in a number of different ways. To take just a few, it's conceivable that legislation and regulations will fall within a force majeure clause, while guidance might not. It might be argued that to the extent that guidance is mere policy, the fact of compliance with that guidance wouldn't be treated in the same way as compliance with laws and regulations from a causation perspective. And equally, it might be argued that complying with soft guidance via social distancing is a matter over which the party seeking relief strictly has control. So those are, I think, red flags to think about. With those points in mind, let's just have a very brief look at some of the guidance that's been issued. I will have to canter through because the government's been issuing guidance in the last week or so more quickly than I can copy and paste links into these slides. So I'll have to move relatively swiftly. The guidance that you see referred to on this slide is non-sector specific guidance for employers generally. It seems to me, just looking at those non-exhaustive examples of the guidance on the slide, it's doubtful that compliance with that sort of guidance would prevent work on site in the majority of instances, but that it may well be more common for compliance with those sorts of requirements to hinder or delay work instead. We also have a sector guide which has been produced by the government, which looks at construction operations in particular, and you'll see on the slides the sorts of guidance that's been given under that document, and they carry on onto this slide. Things like cohorting, staggering of work, cleaning of machinery, that sort of thing. And it's very easy to see how factually, and leaving aside any legal niceties, compliance with that sort of guidance might delay or hinder work on site. Equally, we have had a letter from the Secretary of State which informs the construction industry of site operating procedures, which I think are now in version 3, and those have been produced by the Construction Leadership Council, and they're effectively a more detailed version of the government guidance that I've already referred to. And I think one of the important points to bear in mind, which is not just limited to the site operating procedures specifically, is that very often the guidance that's been published in a variety of different guises is not always consistent. So it may well be necessary in future disputes to subject all the various guidance that's potentially relevant to quite a fine textual analysis. Now, as we all know, the government on Sunday published and announced further guidance, our plan to rebuild, which applies from yesterday. And that made clear that in due course, COVID-19 secure guidance would follow. And I think it's important to note that that COVID-19 secure guidance has now followed for the construction industry. And that's the guidance that's referred to at the bottom of this slide. So I've given links to the various different types of guidance that the government's published in the last few days on that slide. And I think it's going to be important for us all to be au fait with those documents when analysing force majeure in practice in the weeks and months to come. So what are the takeaway points arising out of what I've called the ripple effect? I think that the first point is that one would naturally look to the force majeure clause to see whether the pandemic generally falls within that clause as a starting point. If the cause of non-performance on site was something that wasn't very direct, like a dearth of workers due to illness, it might then be necessary to analyse more specifically what it is that's prevented, hindered or delayed performance, and to ask whether there's an arguable case to the effect that that falls within the force majeure clause. And then thirdly, probably necessary to look at any other contractual provisions which might afford relief, going above and beyond the force majeure clause. And I've referred there to a couple of clauses in the context of NEC 3, which are concerned with changes in the law. And finally, at the bottom of the slide, I've mentioned the fact that I think in practice, it's going to be important for us to be advising clients of the need to maintain adequate records of how it is that they've gone about responding to the COVID-19 pandemic. Touching very briefly on requirement 4 of the list of 5 requirements that I mentioned at the top of this talk, what can those on site do to try and avoid or mitigate the consequences of the pandemic? It seems to me carrying on working rather than shutting down entirely, but doing so in a way with government guidance and legislation. Seeking alternative methods of performance where an original supply chain has been broken, and potentially, as some of the government guidance suggests, moving to staggered or shift working in order to try and mitigate delay. Finally, then, we come on to a couple of other potential issues arising in relation to COVID-19. Firstly, it's important to note that there has been a challenge to the legality of the lockdown, effectively Gina Miller 3, and whether or not that challenge is successful may, it seems to me, have an impact upon the relevant force majeure analysis. And finally, the government has issued guidance on responsible contractual behaviour in the performance and enforcement of contracts impacted by the COVID-19 emergency. Now, effectively, that is a plea not to rely upon black letter legal analysis in support of one's contractual position. Personally, I have difficulty with the sentiment underlying that, because I think it presupposes that the party seeking relief is the only party whose future viability may be on the line, and ultimately contractual risk allocation is a zero-sum game. And it seems to me that there may well be cases where the party refusing relief on force majeure grounds does so in an attempt to survive itself. So perhaps that's most pertinent where that's not the case factually, and the government's effectively asking those with the broadest shoulders to bear the burden rather than to send subcontractors and suppliers to the wall. But it seems to me, in light of the points that are set out at the bottom of that slide, that guidance is likely to be a document which is primarily relevant in commercial discussions, and the courts are unlikely to have undue regard to that when interpreting contracts. So I apologise for the very swift canter through that guidance, but now we're going to move on to the second phase of this session, where we're going to ask Sean Wilkin QC and Adrian Williamson QC to answer a few questions that have come in the past week or so. So if I could start, I think with asking this one of Sean, a question that's come in is, how likely is it that COVID-19 will fall within the standard FM clause wordings?
Good morning, everyone. Thank you for attending. It really depends. You have to be quite careful about whether you're talking about COVID-19 or the legislative response to it, because the two will fall differently. So if you look at COVID-19 itself, you've already seen the definition of act of God. I think that would apply, absent Matt's conspiracy theory. In terms of pandemic, epidemic, obviously, if you have that wording, it's rare. There are clauses where it's out there, but if you have that wording, you're in there. More interestingly, plague. There are clauses with this wording. It comes from an old shipping wording. There is a debate out there at present whether COVID-19 is a plague. I think it's quite reasonably arguable that it is. And I say that for two reasons. One, the dictionary definition will catch COVID-19, and two, the relevant case law doesn't confine plague to the Black Death or bubonic plague. It says it's a general disease. We then come on to restraint of princes, a very old clause, but still around. Where you have places that were subject to blockade, it has to be an actual blockade, not anticipated, then that would apply. And there are clauses out there which govern legislation. You would have to have, and this is quite a rare clause, I've seen it about once, a government guidance clause in order for the guidance that is out there to count as force majeure. So there's a definite possibility for COVID-19. I think it's much more unlikely that the guidance itself will be caught by the wording of a force majeure clause. I know Adrian has some thoughts on this, so I'll hand over to him now.
Yes, I was just going to comment on, for example, the JCT clause, and I think this picks up some of the points that have arisen in the questions we've had during the course of Matt's presentation, that I think one needs to work one's way quite carefully through the clause before you get to force majeure. So, for example, in the current standard form, at clause 229.2, there's provision for an extension of time for architects or contract administrators' instructions, which might well arise. Subclause 7, impediment, prevention or default by the employer or effectively the employer's team. And then most relevantly, 13, the exercise by the UK government of any statutory power which directly affects the execution of the works. And I just pause to say there that, of course, the JCT didn't contemplate a situation where parts of the UK government might be taking a radically different line in a situation. But I think the point for present purposes is that before one gets to force majeure, one needs to consider quite carefully whether the event in question is caught by any of the more specific provisions, and that will obviously be the case with the other standard forms as well.
The next question we've got is for Adrian. How likely is it that the rules introduced by government in response to COVID-19 will fall within the term change of law?
Yeah, again, I mean, looking at that clause by way of example, the exercise by the UK government of a statutory power which directly affects the execution of the works, I think that's going to be quite difficult to engage, certainly now, because the UK government, or at least the English government, is positively encouraging contractors to go to site and work. The situation as between March the 23rd and last Sunday may be more difficult, but to engage the clause, it seems to me one's got to show that there is a change in the law, not merely a change in guidance, and also that in the wording of that clause, and there are similar provisions in other clauses, it is directly affecting the execution of the works. So, and the other thing, of course, which is relevant, I think, practically, is that we all know that construction activity has been carrying on since March without social distancing provisions in place. in many cases, and so that has been at least turned a blind eye to by the authorities. So it may be very difficult to argue, even in relation to the earlier period, that there has been a direct effect on the execution of works by a change in the law.
Sean, do you have anything that you want to add on that question?
Yes, I think there is an argument out there, because whilst the guidance classically would not have force of law, the oddity here is that people are going to be prosecuted, so the health and safety executive says, for not complying with social distancing on construction sites. That suggests that the guidance does have force of law, or at least some force, which might get you into the frame of arguing a change in law. I think that argument is much more difficult after the weekend, because the guidance that has come out after the weekend, once you've worked your way through all 13 items of it, it is rather nebulous. And so I think it's rather difficult now to rely on a change of law. But who knows where we will get to, particularly if the government actually starts relying on the COVID Act, because that does make guidance binding. This, of course, is just the position in England. In Scotland and Wales, the position is different.
Thank you. The next question for Sean. What are the major bars to claiming force majeure in relation to COVID-19?
I think the major bar is going to be causation. Obviously, the answer to whether you've got a force majeure wording that applies is a simple yes or no matter of construction. But as we know from Seadrill, if your clause does require causation, you are likely to fail at that stage, I think, without some very unusual facts. I can see an argument in, say, an international supply chain where, say, you were sourcing goods from an area in lockdown. You could say, well, that's force majeure and that has caused, subject to the chain of contracts, impossibility of performance. The guidance itself is going to be difficult because it's going to be very difficult to show that a requirement that you socially distance makes the contract difficult or impossible to perform. It will make the contract more expensive and more time consuming, but the case law says that the fact that a contract is more difficult to perform or more expensive doesn't amount to force majeure. Adrian, any views?
Yeah, just on the supply chain point, I mean, I think even that may be quite difficult because unless you could, for example, establish that you needed materials which could only be procured from Wuhan, and that those had been utterly blocked by the pandemic, I think it's going to be quite difficult, because I think a court might well say, well, in relation to your materials, you couldn't get them from China, but you could get them from Germany, say, and therefore you would have to proceed on that basis. So, but I think you're absolutely right, Sean, that the key battleground is going to be around causation.
The next question in for Adrian. We've already touched upon this to a certain extent. Does social distancing on site amount to force majeure?
Well, I think it probably isn't going to amount to force majeure in many cases, because this is simply a safe and effective way of carrying out the works in the circumstances. One can envisage, for example, in circumstances of say there was a heat wave, for example, then you might have to carry out works in a particular fashion, but that wouldn't be likely to fall within, or in other adverse weather conditions, that wouldn't be likely to fall within a force majeure clause, and I don't think social distancing will either.
Sean, do you have anything to add on that front?
Nothing apart from this, that now from the guidance it is unclear whether in fact you have to socially distance. I say that because Cabinet Office disagrees with Public Health for England. Public Health for England says you've got to keep 2 meters. Cabinet Office now says not really. So if you had difficulties in saying social distance was force majeure before the weekend, I think now you've got even more difficulties.
And the next question for Sean, would mass sickness or isolation amongst employees for a prolonged period amount to force majeure?
Probably not. You can look at a very old case called Lawrence and Twentyman, where a builder was allowed to suspend performance because they were afraid of plague. But that seems to be the exception rather than the rule, because a later case called Atwell says, well, where the contractor has a very close relationship with the employer and the contractor is ill, then yes, they can suspend or they're released from future performance. But if you've got alternate employees and there is a ready labour market, it's unlikely you're going to be able to claim force majeure due to mass sickness of your particular workforce. Adrian?
Yeah, I agreed. And I mean, unless you could establish that the effect of the pandemic was effectively to knock out the UK construction workforce in its entirety or substantially, I think it's going to be difficult.
And the next question for Adrian, what if a contractor's unable to get PPE? There are two things, I think. One is, are contractors now required to provide PPE in order that work can be safely carried out under the new conditions? Well, that in itself is debatable. As Sean says, the guidance is very unclear. The second is, even assuming that PPE was absolutely essential for the safe carrying out of the work, I think a contractor would have to show not merely that PPE was hard to source, which obviously can be shown, but it was impossible or virtually impossible to get it, and that's going to be much harder if the position is that the PPE is available but it's expensive or takes a good while to get hold of. I don't think that's going to engage a force majeure situation. Sean, do you have anything you want to add on that subject?
No.
Next question for Sean then. How does the situation in the construction industry on May the 13th differ from that on March the 23rd?
This is an odd one. I think it's a question more of impression rather than strict legality, because one could say in strict legality it was guidance then and it's guidance now. I would say, and again this is England, not Scotland and Wales, I would say what has happened is there has been a change in emphasis. March 23rd through to May the 10th, the emphasis was on probably not working, probably if you were working, having very strict social distancing, etc., etc. Now the emphasis has gone the other way. Obviously, you know, we are seeing in the press people saying that lockdown is now in effect over. So I think prior to the 10th of May, a more aggressive anti-COVID approach. Now a more relaxed approach seems to be coming down, at least from government. Adrian?
No, I agree with that. Yeah.
The next question for Adrian. We're seeing claims from contractors in which they say that due to the furloughing of their subcontractors' staff, they are entitled to relief via various contractual mechanisms, including force majeure. What is the panel's view on this?
Well, again, I think that's going to be a difficult claim to make good. If we just step back a minute, the basis on which staff are furloughed is that there is absolutely no work for them to do, and therefore it's necessary for their wages to be paid by the government. One can well imagine that many small subcontractors have taken that approach, but if they have no work to do, which is the premise upon which they're furloughing their workers, it's a bit difficult to then say that they were ready, willing and able to perform for their clients, i.e. main contractors, but for the furlough scheme. So I don't think that argument's going to fly.
Sean, do you have anything you want to add?
Nothing from me on that one as well. I agree entirely.
Next question for Sean. If a contract does not require notification by either party of a force majeure event, e.g. a pandemic, and the employer is to give an instruction to the contractor as to how to proceed, is it incumbent upon the employer to declare the FM event?
It's odd to have a force majeure clause without a notice provision. They are fairly standard, but if you didn't have a notice provision, then legally, you wouldn't be obliged to notify, but my advice would be strategically and in every other sense, yes, you should notify. Not least if your contract also contains things like cooperation clauses. So legally, no. Strategically, yes. I'm going to pick up on another question, which is allied to this, which has just come in whilst we've been talking. Someone asked whether, if you had a contract with very little, with no time for completion, would force majeure or the occurrence of legislation, etc., or social distancing be relevant to performance? And I think it could be, assuming there's a diligence clause, definitely relevant to the performance on site. Just picking up that question. Adrian?
Yes, nothing to add on the question that Matt asked Sean, but just in reference to the point that Sean was referring to, the question was, if a subcontract has no EOT provisions or an end date, and COVID has had some effect on progress, is time at large, or does it cause a problem as there's no end date to monitor against? So my view on that is that if one has a very informal subcontract, which has neither a completion date nor any express obligation as to time for performance, I think there would be probably be an implied obligation to proceed with due diligence. And it seems to me that in assessing whether that obligation had or had not been performed, one can take account of all of the circumstances which COVID has imposed. So that would include supply chain issues in relation to both materials and work people, and also constraints on site in terms of social distancing and the like. So I think in that situation, while it wouldn't engage force majeure, and in the circumstances which is positive, the clause certainly wouldn't be there, I do think in relation to due diligence that one could take account of COVID.
Okay, next question for Adrian, a slightly longer one. In assessing extension of time claims in JCT 2016, say, one would usually first ask whether the relevant event has been made out, then ask whether that has caused the contractor any critical delay. But with force majeure, whose definition is not clear, is there a case for arguing that the question of whether force majeure has been made out in any particular case cannot be answered in isolation, and in particular without considering the consequences? The basis for this view would be that force majeure is generally understood to be a fairly catastrophic event, and that it would seem a little odd to conclude that the event had been made out, even though it only caused, say, 1 day delay, because the 2-metre rule itself caused by COVID-19 caused the contractor to take 6 days to do what would normally have been done in 5.
Yeah, so the first answer to this question is that we'd all rather be lawyers than architects because of the obligation which the architect has under the JCT, which, just to remind ourselves, is that if in his opinion or her opinion on receiving notice and particulars under clause 2.27, any of the events which are stated to be a cause delay is a relevant event and completion of the works is likely to be delayed thereby beyond the relevant completion date, then an extension of time is to be given, and one of those events is force majeure. And I think the answer to the question is that once the architect has concluded that there's a force majeure event which is likely to cause delay, then an extension of time must be given, and the architect has to do the best they can in making that assessment. So even though force majeure is a difficult concept to grasp, and even though it may be difficult to assess exactly how much time is due as a consequence, that is the exercise which the contract requires to be done. And even if the ultimate conclusion is it's only, as assumed here, there's only a day's delay, then a day's extension of time must be given.
Sean, do you have anything to add on that?
I agree. The distinction is between the trigger, which is the force majeure, and the consequence, which is the delay. And once you have the trigger, assuming the clause applies, then the consequences flow, even if they are just a day or a smaller period.
Okay, next question for Sean. Assuming an express or implied obligation to proceed regularly and diligently, and or to use best endeavours to prevent delay, is a contractor bound to return to site and proceed with works, even if social distancing would reduce productivity and efficiency to such a level that the contract would no longer be economically viable? NB, articles suggest that where work has continued or been recommenced post-COVID, productivity is 20 to 50% of normal.
Two answers to this. Of course, the guidance as it currently stands says that you only have to socially distance where practicable. There might be a debate, though I wouldn't necessarily want to have it with the health and safety executive, over whether socially distancing was practicable in that circumstance. Assuming that it was, and therefore you had to socially distance, the answer in terms of contract law and force majeure is unfortunately that if your contract becomes economically unviable, that is not force majeure unless the clause says so. It's been well established for a long time that if a contract is rendered more difficult or more expensive to perform, then you're very unlikely, absent some very odd wording, to fall within the force majeure clause. Adrian?
Yeah, I agree, and I think there is potentially, depending how long this all goes on for, an echo of for those of us who have slightly longer memories of what happened in the mid-1970s. So some people may recall then there was hyperinflation, 25% a year, and in those circumstances many contractors were at risk of going bust because their costs were rising and they were faced with fixed price contracts. So this may well create something of a crisis for the construction industry, because the question, I don't know whether Matt read this out, but the question told us that productivity can be as low as 20% as normal with social distancing, and that is obviously going to push a lot of contractors out of business if that persists. But I agree with Sean that the harsh advice, I'm afraid, is that economic constraints do not, generally speaking, make a contract impossible.
Okay, next question for Adrian. Considering the standard form of contract in the construction industry, FIDIC, JCT and NEC, what would be your recommendations to the players of construction industry to draft modified FM clauses?
Well, this is quite a broad question, and I don't think sitting here I'm going to seek to pontificate on what the construction industry should be doing. But I mean, a few points that might be thought about. I mean, one obvious one is, does one want to make express provision for pandemic/epidemics? Secondly, does one want to make express provision for governmental intervention which falls short of the force of law? So many contracts may well provide for a change in the law by way of statute or statutory instrument, but not for something which falls short of that. Thirdly, in relation, one might want to think about cross-border issues. One of the questions which popped up during the course of Matt's presentation was, well, what's the position if you are constrained by regulations or guidance which have been introduced in Italy, but which are impacting upon a contract being performed in the UK? So that's something one might want to think about. And finally, I don't think anyone had, or certainly, as I said, the JCT hadn't contemplated that there might be a distinction between the approach taken by the UK government on the one hand and the devolved governments on the other hand. And clearly many contracts being performed within the UK will have a cross-border element within the four nations, and one might want to make provision for that. As regards the detailed drafting, I think I will leave that to those better qualified than myself. Sean?
Yes, well, I'm going to plug someone else's book here. If you go to Ewan McKendrick's book, Force Majeure and Frustration of Contracts, second edition, 1994, so quite old now, but something 1995. It has a whole section, part 2, on the drafting of force majeure clauses. So that sets out the standard terms, what you might look for. Added to that, there is, of course, one commercial point, the more you put into a force majeure clause. In other words, the more the counterparty thinks you're going to try and weasel out of your obligations, the higher the price will be. And so there is always a trade-off between the risk you will accept of force majeure and the wording that you would put in.
Thank you. Sean, the final question that we've been asked before today's session, again, quite a long one. In a public-private partnership project, consider a case where an SPV enters into a contract with a governmental entity for the construction of a toll road, and the contract has a revenue guarantee clause. Due to government-invoked actions, i.e. total lockdown, the SPV cannot generate the revenue set forth in the contract. And due to the revenue guarantee clause, the contractor places a claim request from the government to compensate its revenue. Assume further that the governmental authority rejects that claim request on the grounds of a declaration of force majeure. In such a case, what options are available to the SPV, and what can you suggest to the SPV as a neutral ADR expert?
That's quite a detailed question as well. If this toll road is in England, I assume it's the M6 toll, and given I acted for them for 3 years, I couldn't be the expert. I don't think we looked at force majeure in that case. Some general high-level comments. If the government is relying on force majeure, relying on its own guidance, that is an interesting position to say the least. Not least given the state of the guidance, and of course it's the government's own guidance. And there is an argument that one party can't rely on what it does or what it chooses to do to get itself within a force majeure clause, depending on the wording of the clause. So that's a kind of level of comment at high level of generality. Adrian?
Yes, there's nothing I wanted to add on that one. I just wanted to make one comment on what Sean said on the last question, which was about the commercial considerations. One thing that may be worth thinking about is that if, as the government appears to think, we're essentially going to be back to normal in the UK generally by, or England anyway, by say the 1st of June, then this may be something of a 9-day wonder, in which case there may be echoes of previous furores over things like YK2000 and the volcanic ash cloud in Iceland, and some of these drafting issues may go away. If, on the other hand, either this pandemic is going to go on a lot longer or pandemics are going to be more of a feature of life, then that's going to be much more of a consideration. And as Sean rightly says, obviously, the more extensive the protection which the contractor gets, the more the price is going to be varied to reflect that. Yeah, thanks.
Thank you, Adrian. I think we probably just have about 2 minutes left before the end of the session. So I don't know whether Sean or Adrian, you have any questions that you've seen pop up on the Q&A feed, which you think would be particularly interesting to talk about.
Matt, shall we just run through them as quickly as we can in one, taking it in turn? So the first question was whether a delay event can be both an employer delay, a relevant event and a relevant matter, and force majeure. For example, if a landlord prevents a tenant and its contractor accessing a building for tenant work. I think that's a reference to the clauses of the JCT which deal with delay and loss and expense on the one hand, and the clause 8.11.1, I think it is, which Matt referred to for non-fault determination. And the answer to that, in my view, is yes. I think the next question, which was about subcontracts with no E2 provisions, we've already dealt with. So perhaps, do you want to see the FIDIC question, Sean?
Yes, I mean, and this plugs into a common theme of many of the questions that we've had whilst this talk has been going on. Remember, force majeure doesn't exist out with your contract, and everything turns on the wording of the clause. So in terms of the FIDIC question, does it boil down to a factual analysis of whether the FM event actually prevents the contractor from correcting the default? The answer to that would be yes. Brackets depending on the word of the clause, because obviously we can see clauses which use cause or others which use impacted, and those are different types of clauses with different consequences. Adrian, the next one.
Yes, so there was a question about distinguishing between force majeure and change of law clauses, where there was a prohibition imposed by the Italian government. I think that again illustrates the point I made earlier, which is that you need to work your way through the clause. Taking the JCT by way of example, if it's an Italian government action, it wouldn't be caught by clause 2.29.13, which refers to action by the UK government, and this would then be force majeure or nothing.
Thank you very much. Well, I think that may be all we have time for in the session this morning. So thank you everyone for dialing in. We hope you found it useful. And I believe that there ought to be some slides following and available shortly after this session if you'd like to have a look at those. Thank you very much.